All right, this lecture supplements the recorded video that accompanied Chapter 16 of the textbook in the modules. And we're dealing with Chapter 16, which deals with situations where the law requires a contract to be in writing. Chapter actually covers two distinct concepts: how the statute of frauds, the writing requirement, affects the enforceability of contracts, and how the Parol Evidence Rule excludes outside evidence to modify a contract. The statute of frauds is a statute, I think, in every single state that requires certain types of contracts to be in writing. It's kind of a confusing name for a statute because it doesn't deal with fraud at all. It just deals with the requirement that certain types of contracts be in writing. As the textbook talks about I guess the original intent of it really was to prevent frauds by requiring contracts to be in writing. But again, what it does is it renders certain types of contracts that might otherwise be enforceable to be not enforceable if they're not in a proper form. The text contains a lengthy section on what constitutes a writing, and I'm not going to be talking about that in this lecture. You can read that on your own. Suffice it to say that a writing doesn't necessarily have to be one piece of paper that both parties to the contract sign. Writing can actually be made up of several different types of communication, which taken together constitute a written contract. The primary purpose of the statute of frauds is to provide reliable evidence of contracts via writing to the party. The different types of contracts that require a writing are outlined on this slide. The most common instance where we encounter statute of fraud issues is contracts involving interest in land. And there's interesting case discussions in the textbook about what constitutes a writing to satisfy the statute of fraud. And there's one of the cases cited in the textbook found an actual contract. The other did not. When you're talking about interest in land, it's not only purchase and sale agreements. It also involves, for instance, leases, including any residential lease that we might sign, but also can include option agreements. So again, if the primary subject of the contract is land, it's subject to the statute of frauds. The second is contracts that cannot, by their terms, be performed within 1 year from the date after the date of formation. And there's a good discussion of that in the textbook. Third, collateral or secondary contracts. Normally these are often described as guarantees. So if you've guaranteed to pay the debt of another, that would have to be in writing. The text accurately points out that this is different from somebody that's actually agreed to perform it, whether or not the other borrower performs. So if you could have, for instance, an oral agreement for a loan. And if one of the parties, but both of the borrowing parties essentially agree directly to pay it, that would not be the subject of the statute of frauds. It really has to be a guarantee. In other words, it's not your debt. Promises in consideration of marriage, and then finally, under the Uniform Commercial Code, contracts for the sale of goods priced at $500 or more. As usual, the text contains very good exhibits that summarize these issues. Exhibit 16.1 deals with the 1-year rule. Exhibit 16.2 deals with collateral contracts, and 16.3 general contracts that must be in writing to be enforceable. So again, it's very helpful to look at these at these exhibits. One more word about what constitutes a writing. Again, a writing can consist of any type of confirmation of an order, an invoice, a sales slip, a check, fax, or an email, or a combination of these items. So again, as I said before, a written contract does not need to consist of a single document in order to constitute an enforceable writing. One document, for instance, may incorporate another document by referring to it and incorporating its terms in there. Several documents may form a single contract if they're physically attached to one another, for instance, by a staple or a paper clip or glue or some other way of binding. And finally, there are cases that say that several documents may form a single contract, even if they're put in a file together. There are numerous other types of contracts that have writing requirements. And their examples of these are various types of consumer credit contracts and contracts involving consumer transactions in general. So a number of these Fair Credit Acts contain requirements of how consumer contracts must be drafted, including disclosures, the size of the type, the number of pages, etc. The textbook talks about premarital agreements and the general rule that some states require each side to have counsel. And I'll talk about the California law regarding premarital agreements in just a moment. There are certain exceptions to the writing requirement that are discussed in the textbook, and these basically involve some kind of equity where it would be unfair to enforce the Parol Evidence Rule. So, for instance, if there's been an oral contract and one side has partially performed, you may end up with a court order requiring the other side to specifically perform that contract. If there's an admission in the course of litigation, there can be an exception to there. And then finally, we talked about the doctrine of promissory estoppel earlier. Again, this requires some kind of justifiable detrimental reliance by one side on another's promise, in which case the court may find an exception to the Statute of Frauds. Okay, in California, we have a specific codes that deal with premarital agreements, and this is contained in the Family Code beginning at section 1600, and it's based on the Uniform Premarital Agreement Act that was promulgated by the National Conference. The Family Code section 1611 states that a premarital agreement shall be in writing and signed by both parties. It is enforceable without consideration. Again, it must be in writing. Section 1612 contains certain limitations on premarital agreements, including the inability to contract away the obligation to pay child support. And there is a restriction on the waiver of the right to collect spousal support, and basically requires that the party against whom enforcement is sought, it has to be represented by independent counsel at the time that the agreement containing the provision was signed. Or even if they do, that if it was unconscionable. So there are real severe limitations on this, and many family law lawyers that I know actually won't be involved in drafting premarital agreements. They refer that out to people that specialize in it, because there is a tremendous risk of liability of malpractice. So again, you can look at the family code if you're interested at these limitations. The other part of the chapter is the parole evidence rule. And this deals with a situation where if we have a contract that doesn't include or actually contradicts oral understandings of one of the parties at the time that the contract was signed. And basically what the parole evidence rule states is that we're not allowed to have testimony regarding oral agreements if a court finds that the written contract itself represents a complete and final statement of the party's agreement. And if so, neither party is allowed to present parole evidence, that is testimony or other evidence of communications between the parties that's not contained in the contract itself. So again, parole evidence is testimony or other evidence of communications with between the parties that's not contained in the written contract. And the problem we run into here is that it does exclude evidence that conflict with clear and complete contracts. However, many parties understand and enter into written contracts with the belief that oral promises that were made during the negotiations but not included in the contract should be part of the contract itself. And it's hard for them to understand that these oral promises or representations are not included. One of the things the courts look for is whether there's what's called an integration clause in a contract. And that's a paragraph essentially says that it's the entire agreement between the parties and excludes representations. So the slide in front of you has an example of a very common integration clause. It reads, this instrument contains the entire agreement between the parties hereto and supersedes any and all prior written and or oral agreements. This agreement may be altered or modified only in a writing signed by the parties hereto. So again, this is a statement of the integration, that this is a complete contract between the parties, and we're not going to allow any external evidence. And it's hard to get around these types of integration clauses in a contract. Again, there are exceptions to the parole evidence rule. A lot of these, again, have some element of equity in it, but the first one is if the parties have actually modified the contracts that afterwards, that is something that's separate. That if you have modification by performance, for instance, that could be an exception where both sides seemingly have performed differently than what is contained in the contract. And as the slide indicates, a property worded integration clause may prohibit enforcement of an oral modification, but it wouldn't necessarily prohibit enforcement of a modification that took place because the parties actually conducted themselves differently. Or the parole evidence used cannot be used as a way around fraud. So if we have a situation where we're trying to show that a contract is voidable or void because it was entered into as a result of some kind of fraud or misrepresentation, that's not going to keep, a parole evidence rule won't keep that out. Other exceptions, if a contract contains ambiguous terms. When terms of contract are ambiguous and require interpretation, evidence is admissible to show the meaning of those terms. Finally, we have some UCC concepts when a written contract is incomplete and it lacks one or more essential terms, the court may allow evidence to fill in those gaps. And finally, under the UCC, and this is a UCC issue that deals only with contracts for the sale of goods, evidence can be introduced to explain or supplement a written contract by showing prior dealings, of course, the way the parties are performed, or generally how the trade deals with these issues. So hopefully this was helpful. As always, the chapter is very well written. And again, as I indicated, the exhibits are wonderful ways to study and understand the concepts. They really set forth in bullet point and easily understandable form some very difficult concepts. So make sure you pay attention to those. This is the end of this recording.